Here we go. You wrote this on January 11th, just recently, because there is a nominee to the the Department of Labor Wage and Hour Division Administrator, David Weil. He's the nominee. He held that position under the Biden administration, and now
or Obama administration. Yeah.
Excuse me. Same, right? The Obama administration, and now the Biden administration has nominated him for that same role. And you wrote this really great article talking about kind of some of his policies under his administration, so to speak, in that role, and kind of a lot of the stuff that he's been talking about here as well. So why don't we talk about it?
Yeah, I love that you can do this, and you're going to have to explain to me how StreamYard works. I started to explore it a bit, but I love the fact that we can talk about this in real time and scroll through the article. And for me, I really fell to this issue by accident. Like I said, because I'm a freelancer, I normally don't focus on labor. I focus on natural resources, kind of other pet issues, Second Amendment, things that are a little more discussed, but this is a little more opaque for people. And when I noticed that he was being considered and no one was talking about it, I kind of thought to myself that someone needs to discuss him a bit more. And who better than a freelancer who would be impacted by his potential rulemaking that he would do should he be returning to the agency. And I was reading through some of his past remarks, some of his administrator observations. They're called AIs. They're like memos for the agency. I can't recall the exact term of it off the top of my head right now, but they're called AIs and they're memos. And he issued several of them relating to independent contractors, the joint employer rule, and I think there's a third caveat that I talked about in the article as well. And this was during his tenure between 2014 and 2017. And I think, oh, perfect, you're scrolling it. So he issued an administrator's interpretation, yes.
Yeah.
That falsely claimed that worker misclassification was a root problem in the workplace. And he concluded, as I mentioned here in the article, that the Fair Labor Standards Act, which is what he would use or what he would tweak to change how workers are classified. He believes that you should use an ABC test to determine if a worker is an independent contractor or employee. And when you use an ABC test, for those of you unfamiliar, it makes you a default employee unless you can competently prove, and you'll have to jump through hurdles and prove through somewhat difficult means if you are an independent contractor. So it makes it harder for workers to be free of traditional employee-employer arrangements. So he's written memos about his desire to look into options like an ABC test. And I've seen some writings from him saying that he would like Congress to implement a ABC test. And as you know, in California, the ABC test has been extremely disastrous. I've never seen a law go into effect so quickly and enact so much pain onto its residents like that of AB 5. And actually, the chief author of AB 5 just resigned from the legislature, interestingly enough, to lead one of the biggest big labor organizations in California. So it's interesting what will happen with the future of AB 5 and kind of her machinations, given her what she did in her tenure. If California lawmakers move away from what she did and kind of undo the damage that AB 5 caused, even with the carve-outs with Prop 22, and there was another bill too that was signed by Gavin Newsom to stop the damage, so to speak, but that didn't really stop the bleeding, as I note in my article. And so it's really interesting. He kind of wants to take California's model and export it nationwide. And that's what actually even the new labor secretary, Marty Walsh, wants to do. He hasn't really boldly come out and say it, but he has said, we would like to explore these options. You haven't really heard any affirmation for independent contractors. There's, I think, lockstep in wanting to pursue this, unless I'm reading this entirely wrong, but I haven't seen any commentary from either the chief labor guy, like I said, Marty Walsh, or this potential confirmed nominee, David Weil, to come back to his old job to give assurances to freelancers, of which there are 59 million strong and growing, or about 36% of the workforce, compared to about 10.8% that are unionized workforce participants. And so it's really interesting how they really want to appeal to this special interest group, big labor, which is very powerful. I was reading somewhere that they have like $11 billion available to them through dues, union paying dues, and other fees that are collected from unionized members. So they're not a weakened force. They're actually really powerful, even though it's not really reflected in the workforce. But they have a lot of money and a lot of sway, especially with the Biden administration. And they were responsible for electing Biden to office. And Biden has supported and given a nod to AB5 on Twitter. He's even supported the PRO Act and different statements he's made since being elected to office, inaugurated into office more accurately. He has said he wants to see Congress pass the PRO Act in some form or fashion. He's frustrated that it hasn't passed because of his focus on having and encouraging or rehabilitating union jobs, which are languishing because the market is moving away from that old framework. We're not in the 1930s anymore. It's 2022. A lot of things have changed. Workforce conditions have improved, but workers are not monolithic anymore. It's not people working in the steel factories, people working in coal mines as unionized workers. Although those professions are greatly noble, and I feel like a lot of them, especially energy workers who are unionized, don't feel like they have their interests heard, given the fact that Keystone Pipeline was canceled. A little bit unrelated to this discussion.
Yeah.
But you see a lot of push for big labor policies, and pro-labor doesn't necessarily mean pro-worker. That's something I want to convey to your audience here, because you're going to see, and you are already initially seeing the conflation of, well, this is pro-labor, therefore it's pro-worker. But you hear from a lot of workers like me, even beyond me, more serious workers and people who have far more clout probably than I do, and who've worked in freelancing a lot longer than I have, who've said, well, workers can't be classified or lumped into a one-size-fits-all approach. It's not legally sound to do. You can't do it because there's no appetite to classify all workers as one and the same, because we're such a individualistic, I would say, country. All people can't be deemed the same when it comes to any other area. Like, I don't think you can regulate everyone equally in certain industries, because there are different skill sets, there's different interests, there's different experience levels. So it'd be really hard for the government to come in and say, you all are employees, when in fact, I'm not an employee. I'm not working for one company full time. I'm working for 4 or 5, maybe 6 companies on a large scale basis, smaller scale basis, per project, per diem basis. And so I shouldn't be regulated as an employee or classified as an employee because my work does not reflect that. And I think a lot of other independent workers are also conveying their frustrations with these desires, whether it's through regulatory fiat under David Weil, potentially returning to his old seat, or seeing Congress potentially weigh in on this. Actually, Congress passed the federal version of AB5, which is known as the Protecting the Right to Organize Act, in the House of Representatives the last 2 years. It's
which
actually
is the PRO Act that you were referring to earlier.
Yes, the PRO Act, yes. And that bill has actually been stonewalled in the Senate because of 3 Democratic holdouts, to the 2 Arizona senators, and then actually one of my senators, Mark Warner, who has a business background, and who's very concerned about reclassifying independent contractors as employees, interestingly enough. So I appreciated his sentiments there. But we don't anticipate Congress even passing it because it's so gridlocked, which is encouraging to me from an independent standpoint. But observers will be like, well, if you change the filibuster rule, then you can see something like this happen. But as it stands right now, pending no changes to the filibuster, God willing, you won't see this rammed through in Congress. So I think people have to focus their efforts on David Weil coming back potentially to the Department of Labor and what he will do. I think I talked to you before we went to the air that there was a memorandum of understanding signed between the Department of Labor and the National Labor Relations Board to crack down on so-called misclassification cases as it relates to joint employer rules, as it relates to independent contractors or employee-employer relationships. So they will look to the regulatory means to change employment law, to change how workers are classified, potentially if Congress does not take that effort into their own hands. So you have to, from a legal standpoint, there's going to be a lot of litigation, perhaps to counter the efforts, counter any rules changes that they enact. So this is something I think lawyers will be really, really impressed upon to look into, maybe take a second look at, and really start to talk to their friends who are freelancers and ask for their concerns and maybe lend some legal help if necessary.